Call the case at this time. This is case CR 22-211624, State of Idaho versus Lori Vallow Daybell. The defendant is here represented by attorneys Jim Archibald and John Thomas. The state is here represented by prosecuting attorneys Rob Wood of Madison County, Lindsay Blake of Fremont County, and Special Prosecutor Rachel Smith. I'll start with the state. Is the state ready to proceed?
Yes, Your Honor.
All right. Is the defense ready to proceed?
Yes, Your Honor.
Very well. Before we begin with the voir dire of this group of jurors, do either the state or the defendant object to the manner in which the jury panel is drawn? From the state?
No, Your Honor.
From the defense?
No objection.
Thank you. Ladies and gentlemen of the jury, thank you for returning this morning. You've been recalled as prospective jurors in this case now before us. I'll again reintroduce my court staff and me. I'm Stephen W. Boyce, the district judge for Fremont County. I'm in charge of the courtroom in this trial. Our court clerk is Shannon Holstein, who will be keeping minutes of the trial proceedings, marking exhibits, and administering oaths. There are also bailiffs here that are assisting the court with maintaining courtroom order. Deputies Ravello, Holmes, and Beish, and they'll be working with the jury as well. The court reporter, Patty Bath, is seated in front of me, takes a stenographic record of everything said, and my staff attorney, Courtney Stallings, will assist me from time to time with legal issues that arise in the case. As we get started, I will note that we've closed this courtroom to public attendance for this purpose of voir dire, but the proceedings are being simulcast to two separate remote locations, one in Ada County, one in Madison County. There's a courtroom conduct order in effect that relates to all locations, including those simulcast locations, and that prohibits the use of any electronic device from recording, taking any photographic pictures, or transmitting any sounds or images from the courtroom or those simulcast locations. So I would advise all that are in attendance in those locations to please comply with that courtroom conduct order, and I would instruct the bailiffs there to confiscate any devices if someone's found to be in violation of those orders of the courtroom conduct. Another matter I'll put on the record as we get started, as I advised the jurors, we would have them sign a juror affirmation when they left last week after completing their questionnaires, affirming that they have not gone into any research or sought out any information about this case. And I have received from all of these prospective jurors that are here before the court now their juror affirmation indicating that everyone has complied with that court's order to not look into the case while the weekend passed after they completed their questionnaires. All right, at this time, each of you is qualified to serve as a juror in this case. In this case, you've each filled out a questionnaire, and those have now been reviewed by the court and by counsel. And after reviewing your responses, it's been determined that you'd be recalled now for further questioning. What we're doing at this time is selecting 18 jurors for this trial, which would be 12 trial jurors and 6 alternates from among you. At this time, then, I will ask the court clerk if we could have a roll call of those jurors in this group that are here and seated by their juror number, please. Madam Clerk.
Juror number 47. Say it out
If
loud
you'll just
so we
say
can
here
record it.
when we call your
Here.
number. Thank you.
Juror number 51. Here. Juror number 102. Here. Juror number 168. Here. Juror number 174. Here. Juror number 278. Juror number 314. Here. Juror number 323. Here. Juror number 338. Here. Juror number 346. Here. Juror number 365. Here. Juror number 459. Here. Juror number 538. Here. Juror number 548. Here. Juror number 693 has failed to appear.
Thank you, Madam Clerk. The court will note then We'll contact juror 693, and I would admonish that juror that for having failed to appear, they may be subject to either a fine or jail time under Idaho Code 22085 or Idaho Code 7610, and they'll be perhaps required to return to court at a later time. So for those of you who appeared this morning, thank you. To assist you in understanding and participating in this jury selection process, I'll then reintroduce you to the case briefly and the lawyers and summarize again what the case is about. When I introduce an individual that's here, I'll ask you to stand and then briefly take your seat. This case has been brought by the state of Idaho. I'll sometimes refer to the state as the prosecution. The state's represented at this trial by Lindsay Blake, who's the Fremont County prosecutor. Ms. Blake, thank you. And Rob Wood, who's the Madison County prosecutor. And also assisting them is Special Prosecutor Rachel Smith. All right, the defendant in this case is here, and it's Lori Vallow Daybell. She's represented by Jim Archibald and also her attorney, John Thomas. This case is a criminal matter, which means the defendant is charged by the state of Idaho with a violation of the law. When you were here last week to complete your questionnaires, the court read in more detail a summary of the charges as contained in the indictment in this case. I'll just reiterate at this time, with regard to the defendant, the state of Idaho alleges that she committed the crimes as follows of count 1, conspiracy to commit first-degree murder and grand theft by deception. Count 2, first-degree murder. Count 3, conspiracy to commit first-degree murder and grand theft by deception. Count 4, first-degree murder. Count 5, conspiracy to commit first-degree murder. And count 7, grand theft. The defendant, Ms. Vallow Daybell, has pled not guilty to all of the charges, and please remember that this is simply a description of those charges. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove her innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crimes beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. I'll next read an instruction regarding your duty as jurors. The duty of the jury is to determine the facts and then apply the law set forth in the instructions I will later give you to those facts. In this way, you will decide the case. In applying the court's instructions as to the controlling law, you must follow those instructions regardless of your opinion of what the law is or what the law should be or what any lawyer may state the law to be. During the course of this trial, including this jury selection process, you're instructed that you are not to discuss the case amongst yourselves or with anyone else, including through the use of email, text messaging, tweeting, blogging, electronic bulletin boards, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet, and do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. At this time, then, I will ask Madam Clerk to administer the oath to the jury panel. If you would all please stand and raise your right hand.
Do you solemnly swear or affirm that you will truthfully answer such questions as may be asked of you by court or counsel, touching upon your qualifications to sit as trial juror in this cause, now on trial, so help you God? Yes. Thank you.
Thank you. You may be seated. All right, at this time, I will note for the jurors, there is a simulcast in a different courtroom that's showing areas of the courtroom. However, it is not showing you. So we're referring to you by juror card numbers, but you are not on camera being displayed to those other locations. I'll note now the clerk has impaneled 15 prospective jurors from this group today, and it will be 14 now with the fail to appear of one of those jurors. Let me start with the state with this question. Will the state stipulate that the jurors were properly called and impaneled for this group?
Yes, Your Honor.
Does the defense also stipulate the jurors are properly called and impaneled?
Yes, Your Honor.
Thank you. And another question then, do the attorneys agree that the jurors are properly seated with their red card numbers, Mr. Wood
Yes.
and Mr. Archibald?
Yes.
Very well. We'll next talk about the nature and purpose of voir dire. In this part of the jury selection, you'll be asked questions touching on your qualifications to serve as jurors in this particular case. This part of the case is known as the voir dire examination. Voir dire is an ancient Anglo-Norman term dating back hundreds of years to the origins of common law. In Old French, it simply means to speak the truth. Voir dire examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold or by some personal experience or special knowledge which you may have concerning the subject matter to be tried. The object is to obtain 12 persons who will impartially try the issues of this case upon the evidence presented in this courtroom without being influenced by other factors. Please understand this questioning is not for the purpose of prying into your personal affairs, but only for the purpose of obtaining an impartial jury. Whenever you need to answer a question, please raise your hand. When called upon to speak, please always identify yourself only by your red card number. Because these proceedings are being stenographically recorded by a court reporter, when you're communicating with the attorneys or with me, it is necessary for you to speak clearly. When you answer questions, please give audible answers such as yes or no, and try not to just shake or nod your head or say uh-huh or uh-uh, because that makes the record unclear later when we are reading it. In addition, please wait for whoever is discussing a question with you for them to finish their sentence before you begin speaking. That way the court reporter can keep a clear record and not be confused by having two people speak at the same time. I'll next indicate that if there are answers to questions, which probably will likely be happening frequently here, that you believe should be answered privately and not in the presence of the other jurors, then we will be taking up individual questioning of jurors when that need arises. If any question is embarrassing for you to answer publicly, or if it deals with subject matter of this case that could prejudice other jurors, then let us know by raising your hand, and we will discuss that answer with you, but don't want to do that in the presence of other jurors. I'll note on that also that many of you do have knowledge of this case from pretrial media coverage and publicity, and please do not discuss any of the facts or details in this case in front of other jurors in this pool. Again, we'll talk to you at some point individually to review that issue further and let the attorneys have questions about that as well. As for the parties here, I would instruct the attorneys for both parties to avoid repeating any question that's already been asked in your voir dire. The attorneys do have the right, however, to direct follow-up questions to a juror regarding that juror's response to a previous question. I'll next talk about the nature and purpose of juror challenges. The jury should be aware that during the following voir dire examination, one or more of you may be challenged. Each side has challenges called for cause, by which I mean they can ask that a juror be excused for some specific reason. In addition, each side has a number of peremptory challenges, by which I mean that each side can challenge a juror and ask that they be excused without giving any reason for the dismissal. If you are excused by either side, please do not feel offended or feel that your honesty or integrity has been questioned, because it has not. At this time, then, the court will begin with its voir dire. I'll now begin the court's portion of the voir dire process, after which the attorneys for both parties will be given an opportunity to make their own voir dire inquiries. Those of you who are not called when I'm asking questions should pay close attention to the questions I'm asking you may be called upon later to answer those same questions. At this time, I'll first address the juror questionnaires that you received and completed, each of you. I'll ask as a group then, is the information that you provided in the jury questionnaire still accurate to the best of your knowledge? If each of you could just raise your hand and indicate yes if in fact the information in your questionnaires is still accurate. Okay, thank you. Is there anyone that feels they need to update or change any answer in those questionnaires at this time? All right, there was no comment there. Let me next discuss the issue of the time commitment. If you're required to serve as a juror in this case, it may be for a period of up to 8 weeks for this trial to be completed, and the question is whether or not such service would create a serious hardship upon you or your family or your business or profession or occupation so as to prevent you from rendering service as a fair and impartial juror in this case. So at this time, let me ask by raise of hand, is there anyone here who feels that that time commitment would cause an undue hardship? Okay, we do have at least one hand. That's juror 548, correct? All right. If you'll give me a moment, I'll review your questionnaire. Did you include that information in your questionnaire? All right, so juror number 548, could you explain to me what the hardship would be if you were required to serve during that time period?
My work policy is they give you 14 days of paid time off. After that, I wouldn't, be paid for the extra time.
Okay, let me review briefly in your questionnaire about your employment information. If I could ask a few follow-up questions there, Juror 548. The company you work for, how large is that company?
They have about 40 employees locally, and they're owned by a larger company out of Alaska.
Did you discuss with your employer the potential that you would have to serve on this trial and how long that may be?
I mentioned it could take 8 weeks.
And what was the response that they provided to you?
That's where they said they cover 14 days, and then I'd have to take paid time off, or no pay, or use my vacation. I have like 2 weeks of vacation.
And do you have any other source of income besides that employment?
My wife works.
All right. Do you feel if you had to serve for that amount of time that would create an undue hardship on you financially?
I do.
All right. Let me ask if there are any follow-up questions from the state, starting there, and then from the defense. Mr. Wood, any follow-up questions for Juror 548 on the hardship question?
Yes, I don't know if I heard you exactly right, and I apologize for that. Did I understand that your company is requiring you to take 14 days of vacation to cover for time you'd spend on jury duty?
They'll pay for 14 days, then anything after that I would have to take vacation or not be paid.
Okay, and do you, can I ask, do you have vacation time?
Currently I have 2 weeks.
2 weeks. So potentially you'd still be left with 4 weeks of not being paid.
Correct.
Thank you.
Any further questions from the state?
No further questions right now, Your Honor.
All right. Mr. Archibald or Mr. Thomas for the defense, any questions on that topic?
Your Honor, we do not object to this juror being excused for hardship.
All right. Does the state have any objection to an excusal for an undue hardship for juror 548?
No.
All right. Thank you. Juror number 548, then the court does find that you presented good cause for an excusal based on an undue hardship that would be presented if you were required to serve. You can be excused at this time. Let me just advise you, first of all, thank you very much for your service and the time you've taken to come and complete your questionnaire and return today. If you decide to discuss this case with anyone, please be careful to respect the privacy of your fellow jurors. Please limit any comments to your own perceptions and feelings. And if anyone wants to discuss this case with you over your objections or is critical of your jury service in any way, please report that to the court because they're not allowed to do that. So with that, juror number 548 can be excused. Okay, thank you. Juror number 314, did you raise your hand as well? All right, if you'll give me just a moment, I'll locate your questionnaire. Juror 314, did you explain a hardship in answering your questionnaire?
Yes, I did.
Okay, if you'll give me just a moment, I'll review that section of it. All right, I've reviewed your questionnaire on that issue. So Juror 314, if you'd like to explain more about how you believe it would present a hardship for you if you were required to serve in this case.
We have booked plane tickets and vacation resort in middle of May, and we would lose that money if we didn't go there.
All right. Are you aware of whether or not you have any kind of trip insurance or an ability to rebook or change the plans to a different date?
I'm not aware of that. Also, I work too. It'd be a little hard for getting out of work. I didn't talk to my employee about it, but
Let me ask the state if there are follow-up questions on Juror 314's request for excusal.
Your Honor, the only question we had for Juror 314 was similar to what the court had asked, is if that trip was in any way refundable or if there was trip insurance on it, which he's answered. So,
insurance, but I'm not sure what I could do. I haven't checked into it.
All right. Any questions from the defense?
Your Honor, we do not object to Juror 314 being excused for hardship.
What's the state's position on this request?
we don't object to him being excused either.
Very well. With that then, Juror 314, the court will find cause for your excusal based on your work issue that you related, as well as a prepaid plans for a trip that would likely overlap with the time frame of this trial. So again, thank you for your service, coming in, completing your questionnaire. As I mentioned to the other juror, please limit any discussions about this case to respect the privacy of your fellow jurors and report to me if anybody insists on talking to you about your jury service and you don't want to talk to them about that. With that then, appreciate your coming here and you can be excused. Is there anyone else that had a concern or question on the time commitment of the case that they wanted to discuss at this time? All right, there were no further responses from the remaining jury pool. I'll next ask, in terms of your knowledge of this case, what I think I'll do is ask the question in sort of a reverse order, not who has heard about the case, but we have information in your questionnaires, and without again, discussing any details. Is there anyone in the jury pool here who knew nothing about this case until I advised you of what the case was about last week when you came in for your questionnaires? Okay, we've got several hands. So just to confirm then, on the back row, Juror 538, you did not know about the case until you came to court last week, is that correct? I'm sorry. 459. Who else raised their hand on the back row? Juror 346. Okay, and you had not heard or didn't know anything about the case until last week? Very well. Anyone else on the back row? Okay, and who on the front row raised their hand? Juror number 278, you don't know anything about the case until last week? I'm sorry, 174. And who else raised their hand? And that's Juror 51? Okay. For the rest of you, we'll discuss more about your information or knowledge about the case individually with you once we've finished questioning for those other jurors that just raised their hands as well. So we'll come back to that topic. Let me next ask general questions about the subject matter of this case. Would the subject matter of this case, which is described within the charges, and those charges involve allegations of counts relating to murder, conspiracy to commit murder, and theft. Is there anything about the subject matter of this case that would make it impossible or difficult for you to fairly and objectively evaluate the evidence in this case and to render a fair and impartial verdict? Very well, no one raised their hands to that question. I'll next go through checking whether there's any impermissible relationships or acquaintances you may have with people involved in the case. Are any of you related by blood or marriage to the defendant, or do any of you know her from any kind of a business or social relationship? There was no response there. And I know these are technical questions, but they're required to be asked through our jury statute. Does the relationship of guardian and ward, master and servant, employer and employee, creditor and debtor, landlord and tenant, boarder or lodger exist between any of you or any of the attorneys or parties in this case? All right, there was no response to that. Are any of you in this jury panel a party in any way to a civil action involving the defendant, Mrs. Vallow Daybell? No response there. Have any of you ever brought a criminal complaint against the defendant, Mrs. Vallow Daybell, or ever been accused in a criminal prosecution by any of the prosecutors in this case? There was no response there. I'll next ask you briefly about any relationship you may have with the lawyers. Before I ask the question, I think it would be helpful for me to have one representative from the state and then the defendants explain who they work with in either a firm or within their offices. So starting with the state, Mr. Wood, if you'd go through the names of the attorneys you're associated with within both your office and Fremont County, and then I'll ask the same of the defense.
Thank you. The attorneys in the Madison County Prosecuting Office are myself, Rob Wood, Mackenzie Cole, Spencer Rammel, Adam Garvin, Troy Evans, and I'll let Ms. Blake speak for Fremont County.
And the attorneys in the Fremont County office are myself, Tanya Rawlings, Rocky Wixom, Blake Hall.
Thank you. And For the defense, Mr. Archibald, do you have anyone in an office you work with?
No, Your Honor.
Thank you. Mr. Thomas?
The attorneys in my firm are Jordan Crane, Jason Gustavez, Tim French, Alex Sosa, Tyler Salveson. I think that's it.
All right. Thank you, counsel. And for those in the jury, these are all attorneys that are practicing over in East Idaho. Do any of you recognize any of those names or have any kind of attorney-client relationship with any of those attorneys or any of those firms? Okay, there was no response to that question from any juror. Are any of you related by blood or marriage to any of the lawyers, or do any of you know any of the lawyers involved and that were just mentioned from any professional, business, or social relationship? Okay, there was no response to that. I'll next ask you questions about your prior jury experience, and I believe the information was also in your questionnaires, but we'll ask that here on the record. Who here has previously sat on a jury that went to a trial? Okay, we do have a couple of responses there. Juror 459, is that correct? Raised your hand. Juror 346, would you explain, was that a civil or criminal case you previously served on? Okay, how long ago was that?
Over 2 years, Your Honor.
And were you part of a jury that arrived at a verdict in that case?
Yes.
Okay, was there anything in that case that would affect your ability to sit as a fair and impartial juror in this case today?
No.
Okay, thank you for those responses. Who else raised their hand about prior jury experience? Okay, if you could hold your card number up a little bit, that'll help me. Thank you. Juror number 102. When did you previously serve as a juror?
I believe it was around 2016.
And where was that?
That was Canyon County.
And was it a criminal or civil case?
I believe it was criminal.
All right. Were you part of were you a juror that helped determine the case and reached a verdict?
Yes, Your Honor.
Okay. Was there anything about that jury service in that prior case that would affect your ability to sit as an impartial juror in this case?
No.
Okay. Thank you for your response. Was there anyone else that has previously sat on a jury? No further responses there. I'll next ask a question, just a yes or no question, and if your answer is yes, we'll talk to you again individually. It's regarding whether or not you've formed any opinion in this case. Has anyone here in this group of jurors formed or expressed any unqualified opinion that the defendant, Mrs. Vallow Daybell, is guilty or is not guilty of the offenses charged in this case? Okay, no one responded to that. Do any of you have any bias or prejudice either for or against the defendant in this case? All right, no one responded to that question. There are a lot of witnesses that were listed in the questionnaire. Let me just ask for each of you, was there any question you needed to change or, thinking back through, add any information about your response as to whether you know any witnesses in this case? Very well, the court will rely on the information in the questionnaires for any follow-up voir dire the attorneys want to conduct on that issue. Regarding instructions in this case, is there anyone here that for whatever reason would be unwilling to follow my instructions to the jury and to apply the law that you must apply in determining this case? All right, there's been no response there. Do any of you have a religious or moral position that would make it impossible for you to sit in judgment of another or to render a fair and impartial verdict in this case? Okay, no one responded to that. Is there anyone here that if you were selected as a juror in this case would be unwilling or unable to render a fair and impartial verdict based upon the evidence presented in this courtroom and the law as instructed by the court? There was no response there. Do any of you have any other reason why you believe you cannot give this case your undivided attention and render a fair and impartial verdict? Okay, there's been no response there. Counsel, at this time, that concludes the court's voir dire in those topics with the exception of the pretrial publicity topics. So if we can go through remaining voir dire with the full group, and then we'll reserve additional questioning for those jurors that have had some pretrial publicity exposure in this case. So why don't we start with the state? They can begin with their voir dire examination of the full panel here. Who's going to be conducting that?
I will be, Your Honor.
Okay, Mr. Wood, you can go ahead and start with your voir dire.
Thank you. Thank you, ladies and gentlemen. Again, my name is Rob Wood. I have the privilege of representing the people of Madison County. Just before I get started, I just want to remind everyone, if I ask a question that anybody feels they want to answer, but they feel uncomfortable answering it in front of everybody, just let us know, and we can do that in a more private setting. We want you to be able to answer completely and honestly without any fears. So, having said that, Juror 174, if I were to ask you, what does the phrase brutal honesty mean? How would you respond to that?
Brutal honesty is just saying exactly how you feel to the best of your knowledge.
Okay, exactly, just saying everything. And part of that, would you agree with me that brutal honesty means saying everything you feel about a question we ask?
Might depend on the situation, but yeah.
Okay.
I think if it requires honesty, yeah.
Right. Thank you. And that's so. As we ask you these questions today, I'd just ask you all to keep that in mind. That those words, brutal honesty. We want you to tell us exactly what you're thinking and feeling. And the reason why is there's a defendant here today who has a right to an impartial and fair trial. And the people of the state of Idaho also have a right to a fair and impartial trial, and we're only going to get there through today if we know exactly what you're thinking and feeling. So it's very important that you answer our questions brutally honestly, and that those answers are complete. There's kind of an analogy I like to give, which is, who here has flown on a plane? Everyone? So we all know how we get on the plane. We put our luggage away, and then the pilot talks to us, and he says, I'm going to land the plane at approximately such and such time. Who here would feel comfortable if the pilot said, I might be able to land this plane? Who here would feel uncomfortable if the pilot said, I might be able to land this plane? Right? Who here would get off if the pilot said, I might be able to land this plane? And so today, ladies and gentlemen, you're the pilot, and we need you to land this plane. It doesn't matter where you land it, but we need you to land the plane. And what that means is, again, going back to those, giving those answers so that we get a fair and impartial jury. The judge briefly hit on following the law as given, not on what you think the law should be, but following the law as given. We've all had a situation where we've had a disagreement with someone, right? Anybody not ever had a disagreement? We've all had a disagreement. And what I think is fair in a disagreement might be different than what someone else thinks is fair in a disagreement. And we may not agree on the rules that we're talking about. And we all have some rule at work or some law or some regulation we don't like. But in this courtroom, to make sure that the defendant and the people of Idaho both get a fair trial, we have to agree on what the law is. And again, as the judge said, he's going to present you with the law. And this law is something that's been put together by the legislature, by the courts. Can everybody in this room commit to following the law as given to you by the judge instead of relying on what you think the law should be? See, can people raise their hands? And so even if you, at the end of the day, you don't like the law as given, will you all still commit to follow that law? Thank you. I know we're going to talk about publicity a little more later, and I'm just going to hit on it briefly. Does anybody here believe that everything they see on the internet is true? I hear some people laughing. Juror 338, why'd you laugh when I said that?
There's a lot of information you see in a lot of opinions that present information as truth, but it's not always the case.
Right. Thank you. Anybody else feel the same way? What we see on the internet? Juror 346, how do you feel about information out there on the internet?
I feel like it's very biased. I feel like the media and news tell people what they believe they want to hear for reviews and not exactly what may be true.
Okay. Does anybody here disagree with that? So is it fair to say everyone here agrees that information they may have received from the internet, from the news, from social media may not be accurate? Okay. The judge asked earlier if you could put aside, and you put in your questionnaires that you could put aside anything that you've read or heard in this case. And one reason why that's important is, as has been pointed out, a lot of what's out there isn't true. Another reason is sometimes you'll hear things and see things online or on the news that you won't see in court because they're not relevant or they don't matter in a case. So the concern that we sometimes have is we get concerned that people are going to wait. In a case like this, they're waiting to hear something. They're waiting to see something that maybe they've seen on the news. And so I'm just asking, can everyone here again commit that anything they've seen or heard before, that they will 100% set that aside and only rely on what they hear in this courtroom in making their decisions? Does anyone think they might have a difficulty doing that? And so, Juror 51, are you okay doing that?
I haven't heard anything on this case.
Oh, well then that will be easy for you, won't
Yeah.
it? That's right, you're on that list. Thank you. Okay. I'm going to briefly speak with you about, the judge briefly spoke with you about the nature of this case. This is a case that deals with murder. It's a case that deals with two of the alleged victims are underage children. And so you may recall in your questionnaire asking if it would bother you to see autopsy photos. There's going to be some evidence in this case that I think you could characterize as emotionally charged, that isn't necessarily easy to look at. Is there anyone here who thinks they're going to have a hard time seeing something like that? Okay, Juror 51, tell me what your concerns are.
Since I hadn't heard anything, I didn't realize these were underage children, and I have 2 children of elementary age, so I could see that could be a possibility. Okay,
but it would be difficult to see that.
Yeah.
And that totally makes sense. And does everyone understand that having an emotional reaction to evidence like that it's normal? As we ask you to make decisions in this case, we're going to be asking you to rely on your common sense and your reason. Do you think that by seeing that, that would put you in a situation where you weren't able to rely on your common sense and reason in judging all of the evidence? Yes, I'm sorry, Juror 51, I'm still asking you that.
Since I don't know any of the evidence, it's hard for me to say right now. I mean, I'd like to see more, I guess, to understand. But I would try to keep my personal feelings out of it, if that's what you're asking.
Yeah, that's what I'm asking, essentially.
Yeah.
So there will be other types of evidence as well. And what we're getting at is, would you be able to rely on your reason and common sense in judging all of the evidence, even though there was something that may have been emotionally charged?
I believe so.
Okay. Thank you. Someone else raised their hand. Is that 459? Tell me what you're thinking.
I pretty much shared the same response. I believe I could rely on my reason and common sense, but would rather not see any emotional charged pictures.
Sure. Well, I think it's probably fair to say that probably everyone here today would rather not see that, correct? This isn't the type of thing people want to see. And I guess I'd just ask, you agree with me that the defendant deserves a fair and impartial trial?
Yes, sir.
And that the people of Idaho deserve a fair and impartial trial?
I do.
And so, the question that we have is, can you, even though you might have to see some of these things, can you commit to still relying on your reason and common sense in judging all of this evidence and remaining fair and impartial?
Yes.
Thank you. Oh, sorry. Ms. Smith is going to continue the rest of our estates board here.
Okay. Ms. Smith.
Your Honor, given my angle, may I speak from the podium? It's hard for me to see the jurors.
If you'd like.
Thank you, Judge. Okay, this is better. I can see everybody. I'm short. Good morning. The judge talked to you about the law in this case, and he read to you some instructions on issues of the law, beyond a reasonable doubt, and the burden of the jurors. And we just want to explore some of that with you, understanding that our job is to follow the court's instructions, and we're not going to change that or alter that. But I want to have the state talk to you a little bit about understanding what ideas you might have, and to assure yourself and the state and Mrs. Vallow Daybell that you can follow the law that the court gives us. Does that make sense, that we want to follow those things? Okay. And to just reiterate, we're not trying to pry. And if we do the follow-up question, when you say, I think, we all say that. I might, I hope, we're going to go, okay, can you be the airline pilot? So if I do that, I'm not trying to be rude or pushy. What I am trying to do is make sure that the people of the state of Idaho and Mrs. Vallow Daybell both know what's inside your head. Okay? Can you commit to not being offended if I do the follow-up on that? It's just too important to both sides. Does that make sense? Okay. Now, the judge read to you the instructions, and he's going to read to you more. He's going to give you instructions throughout the case, and you will get written instructions that you take back to the jury room. That's the law in the case. Each of those crimes that was read to you that Mrs. Vallow Daybell has been accused of will have specific definitions. The judge is going to give you those definitions in writing, okay? They'll have parts, and I like to cook, so I reference it to like a recipe. Other people will call it a chemical formula. I'm just not that scientifically smart, so I go with recipes, okay? So the recipes for these crimes will be given to you by Judge Boyce, and they will each have parts, ingredients. Let's say it's like a chocolate chip cookie, okay? So the ingredients in that recipe will be flour, sugar, chips, and butter. And then a lot of people will be like, wait a minute, that doesn't sound like a very good recipe. It's not what I think it should be. It's not what I think I want it to include. But the jurors in this case are going to commit to follow the definitions given to them by the court, even if it's not what they think it should be or what they want it to be. Does that make sense? Okay. There are some people who are like, Ms. Smith, I have some pretty strong opinions about the criminal justice system. And if the law, that definition given to me, doesn't match what I think it should be or what I want it to be, I'm going to go with my own gut. I'm not going to be able to do and follow the court's instruction. Is there anyone here who feels like if those definitions that the court gives you, which are well researched, established by the legislature, established by the Supreme Court, well-founded and researched by the judge, if you can't follow those instructions because they might differ than what you think it should be, is there anybody here who's going to say, I can't, if it's not what I think it should be, I can't do this? Okay, I see lots of shakes of heads. Maybe we'll start raising hands, and that way I know I've connected and everybody's heard. Is there anybody here who feels like, no, I'd have to go with my own gut? No. I don't see any hands. Thanks. Now the judge is going to tell you and give you the definitions of these various crimes at the end of the case, and you get to take them back and look at them. Okay? He's going to tell you what we must prove beyond a reasonable doubt. And in that will be the definition that we're going to have to prove there are chips, flour, sugar, and butter, right? And we're going to have to supply and prove to you so that you are firmly convinced beyond a reasonable doubt of each and every one of those things, okay? But he's not going to tell you how we have to do it. He's not going to tell you we have to do it in a certain order. He's going to just have to say you have to walk away firmly convinced of each and every one of those things. Does that make sense? Okay, good, thank you. And so when you get back there, there will be some people who may have in their head, I would have liked to have seen a certain thing. So in burglary cases, and Mrs. Vallow Daybell's not accused of that, so we're going to give that example. In burglary cases, a lot of people are like, I got to see fingerprints. If there aren't fingerprints, you can't prove to me burglary. Well, they get back to the jury room, and guess what? In those instructions, that definition on burglary, nowhere in there does it say, you got to give me fingerprints. Okay? And so that's what we're talking about when they say, if it's not what you think it should be, sometimes in your head you'll have things, I want to see a certain type of evidence, or I want to hear a certain thing before I can consider convicting somebody beyond a reasonable doubt. And so my question, follow up on that scenario is two parts. One, in a case involving the murder of children and a mom of 5, Tammy Daybell was a mother of 5, is there anybody here who in their back of their head is thinking, I got to see a certain type of evidence before I could consider convicting someone of that? I heard a no. Is there anybody here who's like, look, if you don't show me a type of evidence, I can't consider a case? All right, I see shakes of heads. No. All right. The second part is, and again, this is individual voir dire, but when it's time to talk to the court on publicity, I want those of you who have heard of something or heard rumors or watched something to say and be thinking when you're asked, hey, I saw something, and if I don't see what I saw on some show or heard on the news, if I don't see that, I can't consider doing this. Or because of that thing I saw, I'm going to make it easier on the state or harder on the state. So when you get into those questions on that line of thought, I want you thinking about those people who heard and saw something to bring that up with the judge. Because this is too important to Mrs. Vallow Daybell and to the people of Idaho and to the victims in this case that you only hold the state to its burden based on the evidence that is in this courtroom only. That's it. Okay? Now moving to the sort of next thing. When we're talking about state's evidence, there are times you will hear situations involving people who are involved in crimes with other people. That's the nature of a conspiracy. Okay? And a lot of people come into the courtroom believing that they've got to see a certain type of evidence, or that they can't consider convicting somebody who didn't do every part of the conspiracy. Okay? Let's throw an example out there of a mob case.
All right, Ms. Smith, could I have a brief sidebar with counsel?
Sure.
What's that? Okay. No, we're good. Let me just confirm with the simulcast if it's... Is it broadcasting simulcast? Okay. All right, we're back on the record. I had a brief sidebar with counsel there, off the record. Ms. Smith, you can continue with your voir dire.
Thank you, Judge. Let me ask a couple of questions of people. If you receive an instruction that says someone is responsible for their behavior and the behavior of others, is there anyone here in a conspiracy case? And let me ask one individual person. Let's start with... I'll just randomly pick picture 346. Ma'am, can you consider an instruction and consider convicting someone for participating in a plan, even if they're not the one who committed the final act?
Can you ask one more time, please?
Sure. If you were presented evidence and told that under the law, a person can be guilty of conduct that they participated in and that they planned, and they're responsible for the actions of people within the plan. Does that make sense?
Yes.
Okay. Can you consider convicting them of everything, even if they didn't do every single part?
No.
Okay. And can you talk to me about that? Why not? Even if you got an instruction from the court on that.
If I had instruction, then yes.
Okay. And so if the instruction from the court said that someone is guilty for participating in the plan, contributing to the plan, even if they didn't do every act, and that's the instruction from the court, could you consider convicting someone?
Yes.
Okay. I thought I saw a juror's hand in juror 338.
Yes. Is that conspiracy? Is that what you're defining? Okay.
Yes.
Thank you.
Yeah. Do you have any concerns with that, juror 338?
No, I just want to make sure I was understanding that you were discussing conspiracy.
Yes. And so under the law in Idaho, everybody can commit, like juror 338, that they can consider convicting somebody even if they're not the one, say, who pulled the trigger. You know, the driver of a getaway car is as guilty as the bank robber. Does that make sense to everyone? Okay. I'm not sure I saw you nod your head, juror 538. Do you have any concerns with that? Okay. Does that make sense to everyone? Okay. Let's talk a little bit about witness credibility. Okay. Sometimes you're going to hear in cases, generally, you will hear about a witness's, say, employment or background or religious belief. And it may be different than your own. Okay. And it may seem strange or different. Is there anybody here, and let's do this one at a time. Let's go to juror 278. Ma'am, if you were to hear testimony from a witness that had religious beliefs that were different than their own, would that cause you trouble in assessing them and deciding whether you believe them or not?
No.
If somebody's religious beliefs were different than your own, would that cause you to automatically disbelieve or believe them?
No.
It wouldn't affect you at all?
No.
Okay. Is there anyone here who thinks, hey, look, if I don't agree with somebody's sort of religious belief or how they behaved, I'm not sure I could consider their testimony? I don't see any hands. Okay. In this particular case, you're going to hear a lot of different types of evidence. Okay. And you're going to hear evidence that sort of builds into a situation where the state is going to accuse Ms. Vallow Daybell of committing a crime based on circumstantial evidence. Okay. Juror 168. Have you heard the phrase circumstantial evidence before?
Yes.
Okay. And do you have any concerns with considering convicting somebody based on circumstantial evidence?
It proves it beyond reasonable doubt. No.
Okay. Thank you. Is there anybody else who's like, Ms. Smith, if what the state provides to me in a case is only circumstantial evidence, only the bits and pieces that lead somewhere, even if I believe it all beyond a reasonable doubt, and I believe it proves the elements that the judge gives me beyond a reasonable doubt, is there anybody who's like, Ms. Smith, I don't think I could consider convicting somebody based on circumstantial evidence? Juror 168, your answer remain the same? Okay.
All right, Ms. Smith, we received a note that one of our jurors needs a break for a moment, so we'll take a brief recess to allow for that, and we'll come right back on the record once the jurors are reconvened. So I'll rise for the jury, please. All right, we'll be in brief recess. Got in?
All right, please.
Thank you. Please be seated. Is the simulcast on?
Yes, Judge.
Okay, thank you. We're back on the record now, case CR 211624. We took a brief recess for the jurors to have a quick break. Ms. Smith, if you'd like to continue with the state's for diary, you may.
Juror 365. Looking at your questionnaire, I noticed you have children, correct?
Yes. Yes, I do.
Okay. And I want to ask you some questions to help make sure I understand some things. If you have a few children, I noticed, and let's say there was a cookie jar in your kitchen, and you told all 4 of them to stay out of the cookie jar, okay?
Okay.
And then you walk in the kitchen, and one of your children has crumbs on their face, chocolate around their mouth, and you look at them and say, "Why'd you eat the cookie?" All right?
Okay.
Would you be firmly convinced that that child ate the cookies?
I would be fairly convinced, yes.
Okay. And so when we're talking about that, that's what we mean by circumstantial evidence. You didn't see them eat the cookie, did you?
Right.
But all of the evidence led you to that conclusion.
Correct. Yes.
Right. Everybody heard my exchange with Juror 365? Okay. Does that make a little bit more sense when we were talking to Juror 168 about circumstances leaving you firmly convinced, correct? And those of us, a lot of us who have had children, have been in a situation where you didn't see them do it, but you were firmly convinced they did something, right? Yeah. Did anybody who, even though if they didn't see it, but they were firmly convinced their child had broken curfew, watched TV when they weren't supposed to, swiped the cookie, maybe even hit their sibling, right? Still held that child accountable, even if they didn't see it. Is there anybody here who had trouble, of those of you who have children, who had trouble holding their child accountable even when you were firmly convinced that they had done something? No. Okay, I don't see any any heads going back and forth. And so a criminal case is like that. All right. I want to switch to another thing. Here in the jury panel, who here has watched CSI? Okay. All right. I see some show of hands. All right. Juror 102. Do you watch a lot of CSI? Okay. Have you just seen a couple?
A long time ago.
Okay. Okay. I also noticed from your questionnaire, ma'am, that you may know you've heard the names of some of the witnesses on the jury list. Did I read your questionnaire correctly?
Yes, ma'am.
Okay. And without getting into specific names of those individuals, but they did work at the crime lab, the Idaho State Police Crime Lab. Is that correct?
Yes, ma'am.
Okay. How much contact did you have with those individuals?
I spoke with them just about every day. There was one individual on the list who trained me on part of my job responsibility while I was there. Most of my interaction was with that individual.
Okay. Now, this is one of those examples where we talk about the things that you might know from outside the courtroom that could affect how you see things in the courtroom. If those individuals testified, could you assess and evaluate their credibility like anyone else? Or would you be inclined to give them a leg up?
No, ma'am, I could assess them like anybody else.
Okay. Is there anything about those experiences that you're going to hold against them, like make it harder for you to decide or automatically believe they aren't telling the truth?
I'm sorry, can you repeat?
Yeah, that was probably a long-winded lawyer question. Sorry about that. Is there anything about that experience or your contact with those individuals that would make you judge them more harshly?
No, ma'am.
Okay. And so in Juror 102, thank you. That is, I need to ask any of the other jurors. I didn't see anyone else in our questionnaires that thought they knew someone on the list, but we can all commit that we're assessing the credibility based on what they say in here, right? I see lots of nods. Thank you. And Juror 102, is there anything about your training or your experience with those individuals that's going to make you think you have insight into any evidence in this case?
No, ma'am.
Okay. What specifically did you do at the lab?
I didn't work in the lab. I was an administrative assistant to the director of forensics.
Okay. Did you have any access to or read any laboratory reports?
No, ma'am.
Okay. Were you given training on any of the forensic testing that the lab does?
No, ma'am.
Okay. And so administrative assistant, again, we don't want to assume. What were your job duties?
A lot of it was, part of it was being the iKits coordinator, so that was the Idaho Sexual Assault Kit Tracking System, and that required me to make sure that all kits followed the timeline given the law, and if they weren't, I had to make contact with various hospitals to make sure they were being on time and finding out where they were. My involvement with lab personnel included getting kit numbers from them. So if there was one in the system or the kit number was incorrect or for whatever reason, I would have to get a kit number from them. That was most of my interaction. They also kept the fleet binders in the lab, and it was part of my responsibility to get those vehicles serviced. So while I had to go to the lab, I had no training or testing or anything to do with actual lab procedures.
Okay. And so thank you for the details. That's actually really helpful. The question we need to ask you is there anything about that contact at the lab that is going to affect your ability to give both Ms. Vallow Daybell and the people of Idaho a fair trial?
No, ma'am.
Okay. No, you can assure both sides there's no impact?
Yes, ma'am.
Thank you. Okay. Now, I started that question, but it led to the CSI question. Now, can I see a show of hands of the others who have seen CSI? Is anybody, I think a lot of people have. It's been around a long time. Is anybody an avid follower of CSI? Okay. No, there's a lot of people out there. It's one of the most popular shows on TV. Juror 323, I saw you raise your hand. Yes. Ma'am, which versions of CSI do you watch?
I've seen CSI New York and Miami. Almost the entire show for CSI New York, and I've watched the entire series for CSI Miami.
Okay. Well, it's wins awards for a reason, right?
That's true.
Right? But I want to ask you, sometimes people who follow those shows get very excited about types of evidence. And so if you don't see some of the evidence that you see in CSI, okay, or if you don't hear about a particular type of test that you're expecting to hear, is there anything about that exposure that would cause you to kind of evaluate the state's evidence here in a different light?
No.
Okay. You know, CSI is a wonderful thing, but it can't affect your evaluation of the evidence here, correct?
Correct.
Okay. And that leads me to a question. You're going to hear cases and evidence, Juror 323, about in a case where you're going to hear that at least one of the victims, we may not know the cause of their death. Okay? So there's two kind of ideas here that, like, what actually caused the person's heart to stop beating and the brain to stop functioning. But you may hear evidence that the manner of death is homicide from the experts. Okay? Does that make sense?
Yes.
And given watching CSI, those are probably terms you've heard on TV a bit, correct?
Correct.
Okay. Given your exposure with CSI, and given that you may hear a person, the experts will allege, and you'll have to decide beyond a reasonable doubt whether a crime of murder was committed, but you may not know exactly how they died. Is there anything about that situation that make it difficult for you to sit in judgment on a case where that's a potential fact pattern?
No.
Okay. Thank you, ma'am. Is there anybody here who heard my conversation with Juror 323 who's like, Ms. Smith, I don't think I could consider convicting somebody of murder, even if an expert says it was. I couldn't consider it if you don't tell me exactly how they died. I see some shakes heads. Is there anyone here who feels that way? Okay. I'm going to turn to my colleagues for a question. We're just going to go through a couple specific things in your questionnaires, and then the state side will be done. Sorry, Judge, I'm just loading my questionnaire.
That's fine.
I thought I was saving paper, so I didn't print all these. Juror 346, you answered some questions on your questionnaire about reasonable doubt. I'd like to ask you about your responses. Let me scan down. In your questionnaire, you were asked to rank things, 1, 2, 3, 4, about statements that were made. Do you remember having to do that?
Yes, ma'am.
Okay. There was a couple of questions about, let me get down there, if my computer will cooperate. Let me ask you a quick thing. let me ask my colleagues where that page is. I'm sorry, my stuff keeps freezing. I apologize, Your Honor. One moment. Thanks. Sorry, I'm trying to be efficient and not print, and it happens. So, but fortunately, the team has it. In your answer about burden of proof and beyond a reasonable doubt, you made the statement that the state should present a case that leaves no room of question. If any doubt exists, the state should not be able to present a hypothetical situation. Ma'am, did you hear the court's instruction on reasonable doubt?
Yes, I did.
Okay. Can you help me understand what your thoughts are on that issue, please?
I actually would like to change my answer to that. If hypothetical can be presented, but it does not mean that there is no unreasonable doubt in that hypothetical question.
Okay, let me ask a question about that. If you understand that the state has to prove every part of that case, each part of the definition the court gives you beyond a reasonable doubt, right?
Yes, ma'am.
Okay. And so that means leaving you firmly convinced.
Correct.
Okay. If you believe each part of what's been given to you beyond a reasonable doubt, but there are other things that you have questions about, that they don't go to any of the parts of the definition you're given, are you still going to be able to consider convicting someone?
That is correct.
Okay. Is there anything about the court's instructions this morning that's been given to you that causes you concern or?
Not at all.
Okay. What about the conversation I've had with you or others today?
I haven't had any conversations with others, and
Oh, I apologize. My conversations with others that you have overheard.
No.
Okay. And you said you would like to change that answer. Could you just give me just a little bit more, because I'm not sure I heard everything.
Just meaning it sounds like from my answer that you believe that if there's any hypothetical that I wouldn't be able to make a judgment or a decision on it. I don't believe that's correct.
Okay. All right. Well, and that's why we're asking, because sometimes the questionnaire, different people read it different ways, right?
Yes, ma'am.
All right. And I saw Juror 51 nodding. Okay. Is there anything on your questionnaire, ma'am, that you would like to clarify or that you had concerns with?
Nothing specific that I can remember, but I just remember going through the questions going, gosh, I mean, it's all hypothetical, so I found it difficult to make sure I was answering the way that I believe and understand.
Right. And you know what? And that makes a lot of sense. And sometimes it requires reflection. Is there anything that you can think of that you would want to change?
Not off the top of my head.
Okay.
It was a week ago.
Okay. Well, and that's good. Is there anyone else here who, upon reflection, like Juror 346, she's heard some information, she heard the court's instruction, and she would modify how she phrased things? Okay. Is there anyone else here who's in that position that I would like to sort of rethink some of the information I gave? No. Okay. Thank you, Your Honor. Nothing else at this time.
All right. Thank you, Ms. Smith. At this time, then, the defense will be allowed to conduct voir dire of the panel. Again, counsel, please refer to jurors by their card number, and please reference the card number on questioning so we keep that straight in the record. Also, as I've indicated to both counsel and the jurors here, avoid discussing any specific details of the case, which will be discussed further in individual voir dire questioning. Who's going to conduct voir dire today? Is that you, Mr. Archibald? All right, Mr. Archibald, you can proceed.
Good morning. A lot of my questions have already been asked by the judge or the counsel, so I'm typically pretty brief. I do want to go over the questionnaires that you filled out last week. I do have some follow-up questions about those. A lot of my questions will be about pretrial publicity. This case has garnered a lot of attention. I'm not going to ask you questions about that as a group so that we don't poison the well, so to speak. So that's why the judge will do individual voir dire about what you've heard about the case, so that we don't educate the others about what you may or may not have heard. So I'll ask that each of you who have heard about the case, that we talk about that individually.
Mr. Archibald, if you could perhaps a little closer to the microphone. I think we're getting a faint signal there.
Okay.
Thank you.
Sorry. Typically, I remain seated with the microphone in front of me, but I'm so far away that I wanted to see your eyes, and I wanted you to see mine as we talk about your qualifications. So I'll start here with Juror 47. I note in your questionnaire that you work for the Ada County Sheriff's Office.
Yes, sir.
And so does your husband.
Yes.
So you've been through post-training?
No, we're professional staff.
Okay. So you're not out arresting people?
No.
And neither is your husband?
No.
So you're in, it's obviously a concern for my clients when we see someone who works for the sheriff's office could be judging them on a jury. You understand that concern? But you're not the, if you heard evidence that she was arrested or put in jail, what does that mean to you?
So can I describe my position? That might help you. So I work as a laundry technician. So I work inside the jail and supervise the female inmate workers. So those women have obviously been arrested, many for different reasons. My job's not to judge whether they're innocent or guilty of those charges. I'm there to protect them and to help them do their job while they're there. We have things we have to get done. We need to keep the jail at jail standard, which means that, I won't go into detail, but the inmates are required to have certain supplies. So I work with the inmates. We fulfill the needs of the jail every day. And so whether they're arrested or not, I don't have any opinion on that. I just work with them. So, and not judging their guilt or innocence.
Okay.
Yeah.
And understanding that people who are arrested, it's because the officer has probable cause. Do you understand that?
Yes.
And that's a lower burden of proof than what jurors are required to find beyond a reasonable doubt. Do you understand that?
Yes.
Okay. So the fact that you work in the laundry at the jail, would that cause my client any concern about your ability to judge her fairly?
No.
All right. Thank you. Juror number 51. I noted on your questionnaire that you're a stay-at-home mom and you have 2 small children.
Yes, sir.
Are you nervous about spending so much time here in court for the next 2 months? Would you rather be excused for hardship, or do you want to remain here?
Yeah, I struggle with that, I guess, because as I put in there, my husband is a pilot, so when he's gone, I'm basically a single mom. He's gone for 3 or 4 days at a time. I do have my dad here to help, but he's 75 years old, so it's a lot for him to take on. So yes, I volunteer almost every day in the school. But we could manage. It's not like I'm losing a huge salary, or I know other people have harder things to overcome than we do. So I ask that you maybe consider that when you're selecting the jury, but we can also make it work.
Well, it's your call, because none of us know what you personally go through. Mm-hmm. So this is kind of your last chance to ask the judge, if you want, hey, Judge, this is going to be
Your Honor, objection. May we approach?
Well, I think I can just sort that out from here, Mr. Archibald. If there's a hardship question, we'll just get to that, and I'll make a further inquiry and rule on it about what the standard would be for that.
So, do you want to stay or do you want to go?
I'd like to go.
All right. Your Honor, I will challenge juror number 51 for hardship.
All right. What's the response from the state?
The response for the state is we'd like an additional opportunity we are opposed to a challenge for cause, and we would like an opportunity to rehabilitate if the court is considering it.
All right. At this time, I'll overrule that challenge. The jurors indicated a concern with hardship, which certainly is legitimate, and I understand. However, the jurors also clearly indicated in both the questionnaire and through responses today that it's a manageable hardship, and the question is whether it becomes an undue burden such that it requires excusal. So it's not necessarily just the option of what jurors want. It's obviously inconvenient for jurors to have a trial of this length, no matter what their circumstances in life. But I appreciate very much the comments of Juror 51 and your ability and willingness to continue to offer service if you're selected for this case. Based on your responses, I am going to overrule that challenge, and Juror 51 will remain on the jury panel for now.
Please don't be offended that I said challenge. Sometimes jurors, does that mean he doesn't like me? It doesn't mean that at all. Just to help you out.
I actually appreciate it because I kind of was torn on whether I should say anything or not because of the circumstances. So I appreciate the questioning.
Okay, thank you. Juror number 168 indicated on your questionnaire that you're a self-employed carpenter and you need to work.
Yes.
Based upon these questions that you've heard today, are you concerned about your ability to pay the bills if you're not working over the next 2 months?
No, I'm a retired firefighter as well, but it's been 4 years since then, so I receive a pension, so.
Okay.
I do have contracts coming up 1st of June that I am out of state for 3 months, so it's going to run. I have a contract that at 1st of June I will be out of state.
Okay. And so you're, because of you receiving pension money, you're not asking to be let go?
Not for.
Okay. Thank you. Juror number 338. I also note from your questionnaire that you have young children at home.
Yes.
And you work as a therapist.
Correct.
The time required for this case, are you concerned about your ability to provide for your children if you're here for the next 2 months?
My work, I work for St. Luke's. They do offer jury duty pay. So as far as I understand, I wouldn't have an undue financial burden.
Okay. So you're comfortable with that if you're selected as a juror, that will not cause you a hardship?
Correct.
Okay. Juror number 346. You also indicate that you have young children at home. Is that right?
Yes.
And that you also work outside the home?
Correct.
Are you concerned about your ability to provide if you're selected as a juror and required to be here for the next 2 months?
I am not. I've spoken with my employment, and on the questionnaire it stated that we would most likely be out about 3:30 each day, and I have the ability to work from home as well after hours.
Okay. Juror number 365. You indicate on your questionnaire that you have received an order to report for the U.S. Navy next week. Is that right?
Correct.
And would you like to abide by that order?
I would.
Would that help you keep your job?
Yes, it would.
Your Honor, I'd ask that juror number 365 be excused for hardship.
All right, on that, juror, let me ask the state if they have any follow-up questions relating to that naval service.
We do, just a few.
Go ahead, Mr.
What was the juror number here? This is juror 365. As I look at your questionnaire, are you in the Navy Reserves?
Yes, Navy Reserves.
Okay. And this is your scheduled annual training?
Correct.
The 2 weeks a year?
Mm-hmm.
And I noticed that you were asked about keeping your job. If you had to reschedule your annual training, you wouldn't lose your job in the reserves, correct?
I wouldn't lose my job. I would not receive a year of qualified training towards my retirement.
Okay. But are you able to reschedule your annual training?
It all depends on when you join, and so a good year is, for me, the end of May. And so I think with the timing of the trial, it would be after May, and so that would be after the time when I would qualify for that year. So I could, I guess, but it would reduce my qualifying years towards retirement.
Okay. Did you, after you filled out your questionnaire, did you speak with your command at all about the possibility of?
I did. I asked them which superseded, and they said the military orders would.
Okay. I have no further questions.
All right. The court's considered a challenge as it relates to undue hardship for juror 365, based on your further responses and explanations, noting also you raised the concern in your questionnaire. I do find that given the timing of this trial, it would overlap with that required reserve training, as well as potentially interfere with your future years of service credit. So I do find that would constitute an undue hardship. So juror number 365, you can be excused. Again, thank you very much for your service and taking your time to come here today to fill out your questionnaire. Please advise the court if anyone insists on talking to you about the case and you don't want to talk about it. If you do wish to speak to others about it, please be respectful of the process and your fellow jurors. And with that, you can be excused. Thank you. All right, you can continue, Mr. Archibald.
Juror number 459. On your questionnaire, when we talk about burden of proof and whether or not a defendant should be required to testify, you indicated if you don't take the stand, you're probably guilty. Do you remember checking that box?
Vaguely, yes.
Now that you've heard the judge talk about presumption of innocence and burden of proof, do you still believe that?
Could you read the exact question?
I don't have that in front of me, but I'll...
It was just the way the question was worded seemed to trigger the response that I gave.
Okay. So let's say in a trial, the state goes first. They present all their witnesses, they present all their evidence, and then they rest their case. You understand that?
Yes.
So let's say that a defendant with her lawyer says, well, they didn't prove it. So I'm advising you, client, not to testify because the state didn't prove it. Would you then hold that against a defendant to not testify?
No, I would not.
Okay. And that's a pretty common question that you had is, well, yeah, if they don't testify, then they're probably guilty. That's a pretty common sentiment. But now that you understand the state goes first, and then the defendant gets to make a choice. Should I testify or not? What do my lawyers think? And so that's how that process goes. You understand that?
I do.
So if you sat through a trial and a defendant did not testify, you would not hold that against that defendant?
No, I guess in the event that their lawyer instructs them or recommends that they don't, I wouldn't hold it against them. That's all I have to say.
Yeah. Okay. Thank you. Thank you for that clarification. Juror number 538. You also indicated on your questionnaire that you have a toddler at home. Are you concerned about your ability to be here for 2 months and not have care provided for your toddler?
My toddler goes to daycare.
Okay.
Oh no, this is a normal work schedule for me.
Okay. And so you're not asking to be excused for hardship?
I am not.
All right. Your Honor, all the rest of my questions deal with pretrial publicity, and so if we can start individual voir dire.
Okay, thank you, Mr. Archibald. Counsel, to start the individual voir dire, then I want to check with each of you with my list. I had 4 jurors who we were going to speak to. One of them, however, was excused for hardship, so I think the remaining 3 we've got are jurors 338, 323, and 278. So those 3 numbers I called, are you jurors that have had some pretrial exposure to this case and know something about it? Is that correct? Yes. Okay. Why don't we do this then? We'll start at the lowest number. We'll let the rest of the jury retire to the jury room to wait while we conduct individual voir dire. So if everyone will rise, they can be excused, and we'll start with juror 278. If you will remain here, we'll start with your questioning, and then we'll move on to 323 after that.
You'll go as well. We'll grab you guys.
All right, thank you. Please be seated. We, at this point, suspended the simulcast to consider for further potential in-camera questioning of jurors on this issue. It is, however, still on the record here in this courtroom. So, juror number 278, first of all, you're not in trouble because you're sitting there by yourself. This simply goes just to the fact that we don't want we want to be able to talk openly about what you may know about this case without others being influenced. So why don't we start back in order since I passed on that, and you can wait there if you want, Mr. Archibald, but I'll begin with the state on additional voir dire on knowledge of the case, and then I'll move over to the defense. I'll have a few of my own questions actually on that topic. So in your questionnaire, juror 278, you say you've watched or seen about this case through television, internet, and social media. Can you explain a little more of how much of that you've seen on the case or how much you've followed?
I saw it in the news, and also the Dateline of the NBC something. So I followed those too.
Okay. Did you watch a Netflix documentary about it?
No.
Okay. When do you think was the last time you saw something about this on more than the news, like a Dateline special or something?
I can't remember, but did it happen before the pandemic? Before, yeah. So that's 2019 or 2020?
Okay. Looking at the responses in the questionnaire, the court will pass for voir dire at this point to allow both the state and the defense to ask any additional questions of this juror.
Ma'am, you indicated that you saw Dateline a while ago, and news features. How recent the news features? How long ago was it you watched any news about the Vallow Daybell case?
After that, we don't see anything, so it was maybe 2020 was the last one. I can't remember, but after that, there's no, because there's a lot of things going on around, so it was not in the news anymore after those years.
Okay. Anything that you saw on the Dateline or anything you saw a while ago, are you going to be able to put that aside? I see you nodding your head, but
Yes.
I didn't hear anything. I'm sorry.
Yes, I can.
Okay. And sometimes people who are in your position will be sitting in the jury box and they'll be hearing testimony, and they'll be waiting to hear something that they saw on TV or they heard. Are you going to promise us you're not sitting there thinking about, when am I going to hear about something I saw on Dateline?
Yeah, I promise that I won't be biased or something.
Okay. And you understand that it's really important to Ms. Vallow Daybell and to the people of Idaho that your decision is based only on the evidence in this courtroom?
Yes, I do.
Do you have any concerns about your ability to do that and be fair to both sides?
No.
Okay. Thank you, Your Honor. The state has nothing further.
Thank you, Ms. Smith. Mr. Archibald, you can inquire.
Juror number 278, do you recall the details of the Dateline special?
I can't anymore because it's a long time ago. A couple of years.
On your questionnaire, you indicate that you've watched television, internet, and social media about this case. So television would include like the news? Mm-hmm. Is that a yes?
Yes.
And television would include the Dateline special?
Yes.
And then the internet, what would that include?
Like Google about the situation, the case.
Is that something that just pops up on your phone, or do you seek it out?
Yeah, it's pop up in the phone or Facebook or something.
Okay. And so the social media, is that what you're talking about, the Facebook?
Yeah.
And so when an article about the Lori Vallow Daybell case would come up, you'd read it?
Yes.
And what would you think when you would read it?
I was so concerned about the victims and the situation, something.
And would you think, wow, that's pretty bad?
Yes.
Yeah. And you'd start to think this is a really bad situation.
It is.
Yeah. And so because you're the only one who knows what's going on in your mind, I have to make sure that we have jurors who start with a clean slate. Do you think you have a clean slate right now with my client?
I do. And I am willing to listen to the evidence and the proofs in this court.
So does my client have to prove her innocence to you?
Yes.
And she has to prove her innocence to you because of all of these articles that you've read, right?
Yes.
She has to prove her innocence to you because of the news that you watched, right?
Yes.
She has to prove her innocence to you because of this Dateline special that you watched, right?
Yes.
Your Honor, I challenge Juror 278 for bias. I do appreciate your responses. Thank you very much.
Thank you. Any response from the state?
Just briefly, I want to make sure there's not some confusion, if I may, Your Honor.
Go ahead.
Ma'am, you heard the court's instruction earlier, correct?
Correct.
Okay. And do you understand that the state of Idaho, the people of Idaho, have to prove Ms. Vallow guilty beyond a reasonable doubt?
Yes.
Okay. If the people of Idaho, the prosecution, does not prove her guilty beyond a reasonable doubt, then the jurors must find her not guilty. Are you aware of that?
Can you repeat your question again?
Sure. In this case, the court is going to instruct you that the burden of proof is on the people of the state of Idaho, the prosecutors. Are you aware of that?
Yes.
And if the prosecutors don't prove the charges beyond a reasonable doubt, then the jurors must find Ms. Vallow Daybell not guilty.
Yes.
Okay. And because the burden of proof is on the prosecutors, Ms. Vallow Daybell doesn't have to do anything.
Yes.
Okay. And can you hold the state of Idaho, the people of Idaho, the prosecutors, to their burden of proof?
Yes.
Okay. Is there anything about your exposure to news articles or the internet or Dateline that's going to make it so that you make the prosecutor's job easier?
Yes.
Okay. What is that?
That I will be unbiased.
Okay.
And I would listen to the prosecutors.
Okay. Thank you. One moment, if I may, Your Honor.
Yes.
Are you willing to follow the instructions of the court?
Yes, I do.
Okay. Thank you. Nothing from the state judge.
All right. I've considered the challenge as to this particular juror. The jurors indicated an exposure to some pretrial publicity in the form of documentaries and news stories. The court, before this individual, Voir, went through an instruction as it relates specifically to the presumption of innocence. There's been some contradictory responses. In particular, the court's concerned with responses given that appear there may be, in this juror's mind, at least some shifting of the burden, which would be impermissible based on that consumption of this pretrial media. And it's enough of a concern to me that I believe this juror, the challenge for cause should be granted in order to ensure that the defendants got a jury that completely understands the presumption of innocence burden that the state would have in this case. So for this juror 278, very much appreciate your service, and I appreciate your responses today. Again, nothing wrong with any of your answers or what you've indicated. However, with that concern, the court will grant the defense challenge, and juror number 278 will be excused from further service. Thank you very much for reporting today and for your time. And if you want to discuss the case, you may, but respect your fellow jurors, please. And also, if somebody insists on talking to you and you don't want to about the case, please report that to me. All right, with that, Juror 278 is excused. We'll next have 323 brought in. 323. Thank you. We'll continue voir dire with juror number 323 individually. This juror's indicated some pretrial knowledge of the case based on responses in the questionnaire. Juror 323, are the answers in your questionnaire still true and accurate to the best of your knowledge?
Yes.
All right. Let me ask you this kind of general question. Based on what you've seen in the media, do you know what all this defendant is charged with, or did you know that before you came in to get your questionnaire last week?
I only found out what they were charged with after I came in last week.
Okay. And do you know about any other charges?
No.
Beyond what's been indicated here?
No.
Okay. And you indicated you've seen about the case on the local news station KTVB, is that correct?
Correct.
All right, that concludes the court's questions on voir dire. If the state would like to question this witness, you may. I'm sorry, not witness, juror.
That would be a fast trial, Judge.
Yeah.
Ma'am, I'm going to stand up if you don't mind, Your Honor.
Yes.
Good morning again.
Good morning.
Okay. And can you tell us a little bit about the specific, what your memory is of what you saw?
Just the headlines. I don't really read too much into news articles except for the headlines, other than her kids are dead and something about husbands, and that's about it. Outside of headlines, I don't know much.
Okay. And how many do you think you've seen over the course of the last year?
I don't know. At least like 20.
Okay.
But it's just the headlines, and half the time I don't even read them. I just scroll because I see the picture and just keep scrolling through, like Facebook.
Okay. And so it's things that pop up in your social media feed?
Correct.
Okay. Is it mostly your local media?
Yes.
All right. The local TV station?
Correct.
Okay. Have you watched any of the news since you got your jury summons?
No.
Okay. You understand that in this situation, both sides, Ms. Vallow Daybell and the people of Idaho, really need jurors who evaluate the evidence and make a decision based on what occurs in this courtroom only.
Correct.
Okay. Is there anything about your exposure to that information in your local media market here in Boise? Okay. Anything about those stories, that news, that's going to make it hard for you to give both sides a fair shake?
No, based off headlines are just headlines. You don't know the whole story. There's two sides to every story, and I prefer to go off of the facts, and headlines aren't facts.
Okay. Now, the court read you a couple instructions at the beginning of the day. He talked to you about burden of proof.
Correct.
Okay. And presumption of innocence.
Correct.
Okay. And in the courts in this country, and in Idaho specifically, the burden of proof is on the people, the prosecutors. Are you aware of that?
Yes.
Okay. And the state has to prove beyond a reasonable doubt every part of any crime we bring, right?
Correct.
Okay. And if we fail to do it, fail to prove a charge or any of the charges beyond a reasonable doubt, the defendant must be found not guilty.
Correct.
Okay. And so is anything that you've read from the media, anything you've read from the news or you heard, going to make it hard? Like, if we don't do our job and we fail to prove our case, but there's something out there that you've read or a headline you've seen, is that going to cause you to pause in doing your duty to vote or not guilty?
No.
Okay. And you understand it's the state's job, the prosecutor's job, and only the prosecutor's job to prove beyond a reasonable doubt that she's guilty of the crimes charged.
Correct.
Okay. And there's nothing about the stories you've heard or seen that's going to make you want her to prove you anything.
No.
Okay. You understand she doesn't have to do a thing, right?
Exactly, yes.
Okay. It's the state's job and only the state's job.
Correct.
Is there anything about what you've heard that you're going to feel like it's going to make it easier for us?
No.
Okay. Thank you. I have nothing further, Judge.
Thank you, Ms. Smith. Mr. Archibald, you can inquire of the juror.
Juror number 323. You're the juror who likes CSI.
Correct.
Okay. And the news that you had seen about this case was mostly on KTVB.
Correct, yeah.
And you mentioned social media. What?
I follow KTVB on Facebook just for, like local news or like the events happening this week or traffic and stuff.
Okay. So you wouldn't be sitting down watching a TV seeing KTVB. It'd show up on your phone.
No, I don't watch it like that. I don't watch the TV like that.
Okay. And did you watch the Netflix special about this case?
I did not know that there was one.
Okay. Did you watch the Dateline special?
No.
Did you watch the Lifetime movie?
No, I didn't know there was one.
Very good. You indicate in your questionnaire that she had issues with her lawyer.
I did see that off of a headline that there was something about her lawyer, but it was at least 6 months ago or so.
Okay.
I just remember bits and pieces off of the headlines, but I don't know really what's happening.
And so do you know enough about that issue to know that that wasn't about me?
No, actually I don't.
Okay. All right. So with the juror in your state of mind, knowing what you know, would you be hesitant to have you on this jury judging Lori Vallow Daybell?
No.
Okay. You believe you can give her a fair and impartial trial?
Yes, I do.
You believe you can start out with her with a clean slate?
Correct.
You're not going to make her prove her innocence based upon the headlines that you've read?
No, that's the state's job.
Okay. All right. Very good. Thank you.
All right. Thanks, counsel. On further inquiry, the court's not received any challenge, and juror number 323 will not be challenged for cause. So I'll have you return to the jury room for further instruction. Please don't discuss anything that we just discussed here in court with any of the other jurors, and you'll get some additional instruction here shortly. The last juror we'll talk to then is juror 338.
Your Honor, before the next juror comes in, could we just chat once?
Sure. All right, make sure that's closed. Yes.
If the state just wants to inquire if there's any concern about her concerns about the attorney comment, not so much about the media, but the problems that Ms. Vallow Daybell had with an attorney. The state would not want to set up any issues on appeal if she is critical of defense counsel because of that. That's we didn't really want to have that conversation in front of her. That's my only concern is if she's got some idea that, Ms. Vallow Daybell's being cheated by an attorney, that's the state's concern.
All right. We didn't delve into that with her here. She made a comment about she did volunteer that comment.
Yes.
In the questionnaire, not as something she had heard, but sort of volunteered that about things she had heard. Does the defense think we ought to have any follow-up on the question of whether there's issues with her lawyer? I don't know what she's talking about with that response.
We're looking at we did a quick look. There's some local articles, and it's not just TV, about Mark Means. And so that's what causes us to, and it says Vallow Daybell attorney kicked off case, Vallow attorney disqualified. Apparently there's been some multiple articles and or news things in the Boise market on this issue. The fact that it just troubles the state a little bit, that comment that maybe she's not being completely forthcoming about what she's seen with regard to Ms. Vallow Daybell's counsel. And I would worry that would could impact her assessment of defense counsel's performance. There's quite a few articles in the Boise market about Ms. Vallow Daybell basically not having a good lawyer or lawyer getting kicked off.
From the defense, Mr. Archibald, your thoughts on that?
Your Honor, I understand the state's concern about that. I'm okay if we excuse juror number 323.
We'll join in that, Judge.
All right. Well, that is a interesting response that came up on page 16, line 18 of the questionnaire. The question was, will you be able to put out of your mind what you have read or heard and render an impartial verdict? And then the answer, yes, because all I know is she's on trial and her kids are dead. Also, she has issues with her lawyer. So that is strange enough that it could potentially, I think, lead to a change in the way she'd perceive the case and fairness to the defense. So based on the stipulation of the parties, the court will agree that there's good cause to have juror number 323 excused for potential or actual bias. So we'll have her brought back in with the rest of the group, and I'll advise her of that after we finish the last one, and that's juror 338. So if they could be brought in individually. All right, thank you. Juror number 338 has been brought back in for individual voir dire questioning. This juror has stated some prior knowledge about this case, indicating in your questionnaire that you have heard and read about it from local news sources, not a lot of other details. So let me just clarify that. Is it correct that you have heard about the case in the media?
Yes, yeah. I think when the case first was alleged to have happened, it was been a few years since I've read much about it, so it's been a while.
All right. Do you know anything about any charges that have been filed against this defendant here or anyone else besides what's been explained to you here in court?
No, just what has been explained in the court.
Okay. And are the rest of the answers you put in your questionnaire accurate about what you know about the case?
Yes, that's correct.
Have you watched any documentaries, anything on Netflix, anything on Dateline, or any other specials like that, or movies?
No, I have not.
Okay. Thank you for those responses. That concludes the court's voir dire questioning as to media. In this case, the state can inquire if you so wish. Ms. Smith.
I had to check the time. Good morning.
Good morning.
It's still morning. You've indicated that you saw some issues and saw some information out. Was it only news sources, or were there any other like links or conversations through social media?
I'm not really on social media besides Strava, which is like a cycling community. So that Strava, it's just an app for cycling and sporting people that track their activities on that application. So just news media, that's the only place that I've seen information on the case.
Okay. And you've heard the court's conversation this morning and instructions about the burden of proof on the state.
Yes.
And then you heard the state's questioning, correct?
Yeah, I did, yes.
Is there anything about that news media that's you're gonna be thinking about when you're trying to evaluate the evidence given to you by the state?
No, I don't think there's anything that's going to stop me from doing that job. I think I like to give the benefit of the doubt before I make any decisions. So.
Okay. And so when sometimes jurors in that position or veneer panel, people sitting there being questioned, they'll say to us, well, I might be comparing, contrasting what I heard in the news to what I'm hearing in the courtroom. Okay.
Understand, yeah.
And humans do that. That's how we are. But you understand that the rules for the people before this case, and that as Judge Boyce is going to tell you, that you can't do that.
Right. That I just have to base what my information on what I hear in the court from the evidence presented.
Okay. Is there anything about what you've heard that's going to make you not hold the state, the prosecutors, to its burden?
No.
Okay. And you recognize we have to prove beyond a reasonable doubt all the parts of the instructions, the crimes we've accused Ms. Vallow Daybell of.
Yes.
Okay. And if the state fails to prove part of its case, is there anything about what you've heard that's going to give you hesitation in voting not guilty?
No.
Now, is there anything about what you've heard that's going to make you want Ms. Vallow Daybell to prove anything?
No.
Okay. You understand the state's job and only the state's job to prove its case beyond a reasonable doubt?
Yes, that's what I understood from the judge's instructions.
Okay. All right. Your Honor, there was a couple other things that were fairly sensitive on his questionnaire that we had wanted to talk to him about, and we were going to approach. Do you want me to do that now?
And the news stories that you watched, did you watch any of the internet specials or?
No, it was just the local news stories. This is really what I think I've read. I just read the stories on their website.
Would my client be nervous about having you on the jury, having seen those news stories?
No, I don't think I drew any conclusions of certainty as to her innocence or guilt after reading the information.
Okay, thank you.
Yes.
All right, that will conclude the individual voir dire of Juror 338. There's no challenge for cause, so the juror can return to the jury room, and then I'm going to address one thing real briefly with counsel after the juror's excused. Then we'll have the remaining jurors brought back in for some final instruction before we move on to the next group.
Yes, Judge. I also, based upon some answers in the questionnaire, wanted to ask juror number 102 some individual questions.
Okay, well, hang on a second and let me just see which. All right. What was the information in the questionnaire that causes the request, Mr. Archibald?
Juror number 102 indicated in the questionnaire that she talked to a lot of her coworkers at St. Luke's. They all say she's guilty.
And which page was that on? Okay, I think I see bottom of page 14. Okay, I see that. I think it is appropriate for an inquiry on that topic for that juror, so we'll have 102 brought in just a moment. The issue I just wanted to briefly indicate on the record is, it hasn't come up yet, but I find it would be really problematic if somebody is aware of or has been made aware of or knows that the defendant has also had charges filed in another jurisdiction, particularly Arizona. I think that knowledge, if a juror did know that, would likely lead to me concluding there'd be some kind of a bias, as generally we don't allow any knowledge of other conduct like that that's been charged. So I'm trying to skirt around that issue. I just wanted to let counsel know that in the course of your questioning as we go through the process. So let's have juror 102, if they could be brought in for a moment, and we'll discuss that issue as it relates to their response. Question 8, page 14.
I'm sorry, which juror, Judge?
102.
102. Judge, the state will just agree on that one, given the knowledge of people at the lab, et cetera. I just think there's a lot of red flags on this, and I think we've talked about it. We would agree with the defense on this one.
Okay, if we'll hold off bringing them in. Does the defense challenge 102 for cause based on those questionnaire responses?
Yes, Your Honor.
All right. The state has indicated there's also an agreement, or at least no objection to dismissal of 102 for cause. As I review that response, also I find it problematic that it may lead to a presumption that is unfair to the defendant, so juror number 102 will also be excused for cause. So I think that clears through the rest of the group there. We'll have the rest brought in and give them further instructions, and then we'll take a quick break, and we've got another group already lined up that was supposed to be here at 10:30, so we're running behind, but we'll do what we can to get that one started shortly. So, yep, we'll bring them all in. We can. I think we really need to kind of go quick and then get this next group in and started, since they have been here for an hour and a half. Thank you. Please be seated. All right, we'll go ahead and get started again. We will restart the simulcast of the proceedings. So, Madam Clerk, if you'll advise me when that's set up, then we'll get on the record. Okay, thank you. We'll go back on the record on KCR 22211624, State versus Lori Vallow. The court conducted individual voir dire with certain jurors and permitted counsel too as well. Based on the individual voir dire, certain jurors were excused. I'll note also that outside of the presence of two of the jurors remaining here, we had additional questioning and challenges arised, and the court made rulings on those. So jurors red card number 102 and jurors 323 are both excused from service in this case based on the challenges raised. I will indicate to both of you, again, thank you so much for your time and service in filling out your questionnaires. If you wish to talk about the case to anyone, please respect your fellow jurors, and if anyone insists on talking to you when you don't want to, please report that to the court. So I'll just have you remain seated for a moment as I excuse the remainder of this panel for efficiency. So now that we're there with those two additional juror challenges, I think it would probably be good to do a final just roll call of the remaining jurors so that everyone's clear on who remains besides those two we just excused. So if you would please hold up your red card number if you are still here and have not been told by the court you've been excused. All right. Once everybody has those numbers written down, let me know, and I'll excuse the panel in a moment. Okay, thank you, jurors. We've got the remaining group then. I'll ask the state at this time, does the state pass this group of jurors for cause at this time?
Yes, Your Honor.
Does the defendant pass this jury group for cause at this time?
Other than what's been previously stated for challenges, I pass the panel for cause, so I don't waive my previous challenges.
Okay, understood, Mr. Archibald. All right, addressing the jurors who remain then, ladies and gentlemen of the jury, you've been passed for cause. We'll continue to question additional small groups of jurors until we reach the number of jurors necessary for the attorneys to exercise their peremptory rights. You will be returning for that process and then advise finally whether or not you remain after peremptory challenges have been exercised. We'll instruct you to contact the jury commissioner, whose business card can be provided to you on your way out, so you have his direct contact information, and you'll receive further instructions regarding when it is that you'll be required to report back again. While you're waiting, if you're approached, questioned, followed, or in any other way bothered by anyone, please report this immediately upon your return. You'll also be asked again to fill out that jury admonishment that you have not done any kind of research or looking into the case between now and when you return to court, and you're still under the court's orders to not do so while you are impaneled as jurors at this point. So that will conclude your service for today, but you're on standby pending further notification from the jury commissioner, and that will conclude our voir dire of this group of jurors. So we'll have them we'll all rise for the jury and have them be dismissed, and then we'll discuss scheduling.
All right.
All right, please be seated. Counsel, it's just about noon. We're running a little longer than I anticipated, which is not really that much of a surprise, but I think we probably logically right now take a quick lunch break. We do have jurors on standby, so my question is, how quickly do you think we can do lunch? Any suggestions?
What do you think? 30 minutes?
That's what I was thinking. Is that enough time for each to grab something quick before we get the next group in? Okay. Yeah, I didn't want to take a full lunch hour for sure. So we'll come back in and have our second group brought in then at 12:30 to start with the voir dire of that group. We'll be in recess until then. All right, we're going back on the record then on CR 22-21-1624, State versus Lori Vallow. We just took our lunch recess. We've got another group of jurors to be brought in. Counsel, as we get started on this next group, I will just note that when we go to the individual voir dire questioning at the end for different issues, we've got juror number 781 advised of some potential issue where they didn't want to sign their juror affirmation because I think they had talked to someone about the case or something. So I'll bring that up with them in the presence of everyone in the individual voir dire section on juror 781, and I think we'll just let that issue remain for the moment and bring that juror in with the rest of the pool. So we've got the second group ready to be brought in at this time for further voir dire. Is the state ready to proceed?
Yes, Your Honor.
Is the defense ready to proceed?
Yes.
Okay, and I'll note on the record counsel is present along with the defendant, so we'll have group number 2 brought in for voir dire. While we're doing that also, counsel, I'll just confirm out of that last group the juror numbers that were passed for cause, and to put that on the record according to the court's records is juror number 47, 51, 168, 174, 338, 346, 459, and 538 is what we came up with of jurors remaining that are passed for cause that will move on to peremptory challenges when we get there. Thank you. Please be seated. Okay, we're on the record on case CR 22-211624, State versus Lori Vallow. At this time, the court would remind all parties in attendance and those viewing the simulcast transmission of this proceeding that there is a court conduct order that prohibits the recording or photographing or any transmitting of any sounds or images or video from those viewing locations. I would ask that all those in attendance abide by that governing order and that it be reported to me if anybody has violated that order, and the bailiffs there are authorized to confiscate any devices from someone who does not comply with the terms of that order. The next matter we'll bring up then is noting that the defense and state are both here, as well as the defendant who is present. We have a group of jurors for Voir at this time. Is the state ready to proceed?
Yes, Your Honor.
All right. Is the defense ready to proceed? Very well. I'll address the jurors now. Ladies and gentlemen of the jury, thank you for returning. You've been recalled as prospective jurors in this case. I'll briefly again reintroduce my staff here. I'm Judge Stephen W. Boyce, District Judge for Fremont County. I'm in charge of the courtroom in these proceedings today. The court clerk is Shannon Holstein, who is seated to my right and keeps track of minutes, trial proceedings, and exhibits, and also administers oaths in the case. There are bailiffs here, Deputies Ravello, Holmes, and Beish, who assist in maintaining courtroom order, working with the jury. The court reporter, Patty Bath, is here taking a stenographic record of what's said during the proceedings, and Courtney Stallings is my staff attorney who will assist me with legal issues from time to time. And she's seated at the desk over by the window. Each of you has been qualified to serve as a juror in this case, and each of you have now filled out a questionnaire that was been reviewed by the court and by counsel, and it's been determined that you were to be recalled for further voir dire questioning today. So the first thing that we do in this trial is to select 18 jurors total, which will be 12 jurors and 6 alternates from among you. At this time then, I will have the clerk do a roll call. I'll further advise that we'll only be referring to you by your red card number, so that's the number on your red card. If you are being questioned or asked specific questions, it will help both the court and the parties keep track of who's making those responses. Just briefly hold your number up if you're called to answer a question for any reason. And at this time, we'll just have the court clerk, if you would, by reference only to those red card numbers, take a roll call of the jurors 1 through 15 who have appeared.
When I call your juror number, I'd ask that you answer audibly for the record. Juror number 745, juror number 746, juror number 755, juror number 756, juror number 776, juror number 781, juror number 829, juror number 876, juror number 894, juror number 929, juror number 961, juror number 1013, juror number 1039, juror number 1051, juror number 1095.
All right, thank you. You were previously introduced to this case when you came to get your questionnaires last week. I'll again briefly reintroduce the parties and their lawyers at this time and summarize what the case is about. The case has been brought by the state of Idaho, who I sometimes will be referring to as the prosecution. The state is represented by Lindsay Blake, who's the prosecutor for Fremont County. Thank you, Ms. Blake. Also, Rob Wood, who's the Madison County prosecuting attorney. Mr. Wood, if you'd stand, please, briefly. And Also, Rachel Smith is a special prosecutor for this case who's also representing the state. The defendant, Lori Vallow Daybell, is represented by her attorney, Jim Archibald, and her other attorney, John Thomas. Thank you, counsel. This case is a criminal matter, which means the defendant has been charged by the state of Idaho with a violation of the law. When you were here last week to complete your questionnaires, I read to you a summary of the charges in the indictment. I'll go through again a more abbreviated summary of those charges that have been filed in this case. With regard to the defendant, the state of Idaho alleges that Lori Vallow Daybell committed the crimes of count 1, conspiracy to commit first-degree murder and grand theft by deception, count 2, first-degree murder, count 3, conspiracy to commit first-degree murder and grand theft by deception, count 4, first-degree murder, count 5, conspiracy to commit first-degree murder, and count 7, grand theft. Mrs. Vallow Daybell has pled not guilty to these charges. Please remember this is simply a description of the charge, it's not evidence. Under our law, in system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove her innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crimes beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. If after considering the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. Regarding the juror's duty, the duty of the jury is to determine the facts and then apply the law set forth in the instructions I'll later give you to those facts. In this way, you will decide the case. In applying the court's instructions as to the controlling law, you must follow those instructions regardless of your opinion of what the law is or what the law should be or what any lawyer may state the law to be. During the course of this trial, including the jury selection process, you are instructed that you are not to discuss this case among yourselves or with anyone else, including any use of email, text messaging, tweeting, blogging, electronic bulletin boards, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. At this time, then, I will ask that the clerk administer an oath to the jury panel. Ladies and gentlemen of the jury, if you would please rise and raise your right hand, I'll have you placed under oath.
Do you solemnly swear or affirm that you will truthfully answer such questions as may be asked of you by court or counsel, touching upon your qualifications to sit as a trial juror in the cause now on trial? So help you God.
Thank you. You can be seated. I'll reflect on the record that all jurors took the oath. The clerk's now impaneled 15 prospective jurors for questioning in small groups today. Will the state stipulate the jurors are properly called and impaneled?
Yes, Your Honor.
Thank you. Does the defense stipulate as well?
Yes.
Very well. In this part of the jury selection, you'll be asked questions touching on your qualifications to serve as jurors in this particular case. This part of the case is known as the Voir examination. Voir is an ancient Anglo-Norman term dating back hundreds of years to the origins of the common law. In Old French, it simply means to speak the truth. Voir examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold or by some personal experience or special knowledge which you may have concerning the subject matter to be tried. The object is to obtain 12 persons who will impartially try the issues of this case upon the evidence presented in this courtroom without being influenced by any other factors. Please understand this questioning is not for the purpose of prying into your personal affairs, but is only for the purpose of obtaining an impartial jury. Whenever you need to answer a question, I'll ask that you raise your hand and notify us. And when called upon to speak, please identify yourself by using that red card and the number thereon. Because these proceedings are being stenographically recorded by a court reporter, when you're communicating with the attorneys or with me, please answer audibly with answers such as yes or no instead of shaking your head or making gestures or saying uh-huh or uh-uh. So the court reporter can clearly keep a record of what was said. Also, please avoid talking at the same time as anyone asking you a question so the record is clear. Importantly here, we will have an opportunity for what we'll call individual voir dire. We'll discuss issues relating to pretrial publicity in the case, as well as any other sensitive personal subjects that you don't want to discuss in front of your fellow jurors, so that will be done in a more private setting. In this case, as I mentioned, there's been many people exposed to pretrial media coverage and publicity, and so in answering any questions with the whole group, please don't refer to any facts you know or tend to know or purport to know about the case from that media coverage, as we'll have an opportunity to discuss that with you individually so that other jurors don't hear information that they should not hear during this process. I'll also at this time ask the attorneys to avoid repeating any questions already asked by the court so we can keep things moving. The attorneys do have the right, however, to direct follow-up questions to any juror regarding that juror's response to previous questions. I'll talk about juror challenges next. The jury should be aware that during and following this examination, one or more of you may be challenged. Each side has challenges called for cause, which means they can ask that a juror be excused for some specific reason. In addition, each side will have a number of what are called peremptory challenges, and that means it's a challenge where they can ask a juror be excused without giving any reason for the dismissal. If you're excused by either side, please do not feel offended or feel that your honesty or integrity has been questioned, because it has not. At this time then, the court will begin with the voir dire of the court, after which the attorneys for both parties will be given an opportunity to make their own voir dire examinations. If you're not called on a specific question that I have, or the attorneys, please listen, as you may be called upon later to answer those same questions. I'll start off now by questioning about the juror questionnaires. As to the whole jury panel here of 15, the question is, are the answers given by each of you on the questionnaire still true and accurate to the best of your knowledge? Okay, everyone's indicated yes. Let me next talk about the time frame for this trial. If you're required to serve as a juror in this case, as I mentioned last week, it may be for a period of approximately 8 weeks. And the question is whether or not that would create a serious hardship upon you or your family, or your business or profession or occupation, so as to prevent you from rendering service as a fair and impartial juror in this case. So if you believe it would be a hardship for you to serve for that period of time, I would ask at this time that you please raise your red card number if you think that applies. Okay, we do have jurors. If you'll keep those held up for just a second longer, I'll make a list. 1095, 961, 829, 781, and 746 have responded to that question. Let me walk through those in order then, starting with the lowest number. So juror 746, you've indicated you believe it would be a hardship if you were required to serve for that period of time. You've indicated that as well. It appears in your questionnaire. Would you please offer an explanation as to how you believe you'd suffer a hardship if you had to serve?
My best friend was just diagnosed with brain cancer, and I'm going to be a care provider for her during radiation and chemotherapy. In the questionnaire, I said I did not know the timeline. I now know that she will start treatment next week.
And what is the nature of your relationship with this person? I know you said best friend. Can you be a little more specific on what you believe your responsibilities will be through that process?
I am a nurse, so I was going to be there to help her through her cares, as she's most likely going to be pretty sick from her treatment. So to help drive her to and from appointments and to help her through the disease process.
All right. And to your knowledge, will you be primarily responsible for that, or are there a number of other people that may be able to assist as well?
there will be a number of people helping her.
All right, let me pass to the state for any follow-up questions on the hardship that's been expressed by Juror 746.
The state does not have any follow-up questions, Your Honor.
All right, from the defense.
Your Honor, we do not object to this juror being excused for hardship.
All right, does the state have any objection to an excusal for hardship?
Given that additional explanation, we do not, Your Honor.
Very well. Juror 746, we reviewed that in your questionnaire. Finding that additional explanation rises to the level where it could create an undue hardship for you. You'll be excused for that purpose. Thank you for appearing, for filling out your questionnaire. I'll just let you know as you leave that you may discuss the case with anyone now that you've been released. However, you're not required to. If you do choose to discuss your service as a juror, then please be respectful of the feelings of your fellow jurors in the process. And if anybody is critical of your service or insists on talking to you when you don't want to talk to them, please report that immediately to the court and we'll follow up with that. So that will complete the voir dire for Juror 746, and you're excused, ma'am. Let's next talk to juror number 781. All right. Juror 781, in your questionnaire, you did not indicate that I saw a hardship being listed. Would you describe what you believe would be a hardship for your service?
Coincidentally, my brother just got diagnosed with stage 3 lung cancer. Just had the PET scan done, and we found out 2 days ago. I'll be taking care of him along with my wife. I'm the only family he has here in Boise.
And he's here locally as well, your brother?
I'm sorry?
Your brother does live here locally?
Yes, here in Boise.
All right. Any follow-up questions from the state as to the hardship expressed by Juror 781?
No, Your Honor, and the state would not have an objection to releasing him given that information.
All right. From the defense?
The defense does not object to his hardship.
Okay. Juror 781, sorry to hear of that news. You may be excused with the thanks of the court for expressing this hardship. As I mentioned to the other juror, if you choose to talk about the case to someone, do that voluntarily only. If someone insists on talking to you, please report that to the court. And if you do talk about it, please respect the feelings of your other jurors in any comments that you make. And with that, you have the court's thanks and you can be excused for today. You're welcome. Let's next talk to juror number 829. All right, juror 829, in your questionnaire also, I didn't see any indication of a potential hardship. Would you explain to the court?
Yes. So after I understood what case this was, I discreetly consulted with my HR from my work to make sure that I was able to afford being able to come here for the expected length of the trial. They only offered 10 days worth of pay. So the concern was because it wasn't a guaranteed covering for income from my household, it was going to potentially lead to a problem.
All right, do you feel it would create a financial hardship on you if you were in fact required to be here for the full 8 weeks? If you were required to be here for the entire 8 weeks, do you think that would create a financial hardship for you or your family?
I do believe that is a possibility.
All right, I'll ask if the state has any further questions for juror 829.
No, Your Honor, and with that additional information, the state would not have an objection to him being released.
All right, I'll hear from the defense then on the issue.
The defense does not object to juror 829 being excused for hardship.
All right, thank you, Juror 829. With that explanation, the court will also find there's good cause to allow you to be excused based on the hardship you've expressed. I appreciate you checking with your employer and providing that additional information today. Did you hear the instructions I gave to the prior to about discussing the case afterwards? Did you hear the admonishment about discussing the case once you leave? Okay, if anybody does insist on contacting you, please just let the court know. You have the court's thanks for appearing and the time you spent, and you can be excused. Juror number 961.
Thanks.
All right, for Juror 961 in your questionnaire also, you didn't provide explanation of a hardships there, so would you please describe what the hardship would be if you had to serve on this case?
I suffer from acute chronic anxiety as well as depression and a certain amount of post-traumatic stress disorder. And after consulting with my therapist, particularly in regards to the duration of this case, we were both very concerned about the possibility of further complications as a result of that. And in fact, I brought a note with me from my therapist for the court to use if need be.
Okay, I appreciate that, Juror 961. If you don't mind, please pass that note to the bailiff, and I will consider that information and allow the state and defense to review it as well. All right, if you'd please pass that along and let the state review it as well as the defense. All right, Mr. Bailiff, you can return the note to the juror, please. Thank you. Does the state have any inquiry of Juror 961 regarding the request to be excused for hardship?
No, Your Honor. Based on the state's review of the note as well as the representations made by the juror, the state would have no objection to releasing him.
Thank you, Ms. Blake. Mr. Archibald?
The defense does not object to Juror 961 being excused for hardship.
All right, thank you, counsel. Court has as well reviewed the information received from the juror today as well as the note provided from a counselor. Upon consideration of that, Juror 961, the court does find a hardship would be had by you if you were required to serve during the duration of this trial, so you can be excused based on an undue hardship. Again, thank you for your time you've put into answering the questionnaire and appearing today. Regarding your service when you leave, as I mentioned, if anything comes up you think needs to be reported to the court, please let the court know. All right, thank you. Juror 1095.
I've been, first of all, I have a claim with Walmart because I tripped and fell over a box there and I cracked my kneecap. So I've started physical therapy this week. I think it's the 6th, I want to say. I could be wrong, but I think it's the 6th. And then plus I filed SSI and I was denied, so I'm appealing that. and I am homeless, so I live out of my car, but a friend of mine's father is letting me stay in his airplane hangar in the apartment that he has there, and it's clear in Middleton. And if I end up being on this trial, and as long as it lasts, they will boot me because they don't want just it being with all my stuff there, and I'm not going to be there. And to be cleaned and showered and all that good stuff, so, which I care about, so.
All right. I appreciate that information you provided as it relates to hardship.
Plus, it's in Middleton.
Explain to me how far Middleton is from the courthouse.
It's about 45 minutes.
Okay, thank
Yeah,
you.
you have
for that.
Star, then Middleton, and then Caldwell's on the other side. It's before Middleton.
All right. Does the state have any requested follow-up questionnaire or questions for Juror 1095?
No, Your Honor. Given the representations made today with that additional information, the state does not have any objection to excusing this juror.
All right, thank you. From the defense, Mr. Archibald?
The defense does not object to Juror 1095 being excused for hardship.
All right, the court's considered that explanation as well. I find good cause exists to allow for Juror 1095 to be excused for an expressed hardship for the reasons she stated. Juror 1095, then you can be excused. Thank you for your service. Best of luck. And again, if anyone bothers you about needing to talk about this case and you don't want to talk to them, please report that to the court. If you do want to talk to anyone about it, please be respectful of the court process as well as your fellow jurors' feelings on anything you discuss. And with that, you can go ahead and go. You're welcome. All right, for the remaining jurors here, was there anyone else that expressed any concern over the time commitment of the case and hardship? All right, there's no further responses there. The next topic, I'm just going to explain the topic, but we'll come back to that. The topic is as it relates to previous knowledge of the case. And if you'll give me just a moment to update my list. All right, in this case, there has been a significant amount of pretrial publicity and media attention. Some of you have seen some of that information, some more than others. The concern here is the court does not want those who do not know about the case to hear about it from other jurors who are explaining what they do know. So for that reason, we're going to conduct individual questioning on those topics. So I will pass on that issue for now, but in order to determine who we're going to talk to, let me ask this way. If you indicated you don't know about the case and you did not know anything about the case until the court explained the charges to you last week, so for those of you who don't know about the case and haven't read about it or seen any pretrial publicity, would you please raise your red card at this time?